Good morning. Welcome to our webinar series on law and geopolitics. My name is Angela Zhang. I'm the director of the Center for Chinese Law at the University of Hong Kong. Today, we're going to discuss a topic that has captured tremendous attention in both the East and the West. That is the sanction laws in the Russia-Ukraine war. As our audience know, the West has so far not engaged in any military actions against Russia, but has rather relied on sanctions as a weapon to put pressures on Russia to stop the war in Ukraine. The impact of these sanctions are not only immediately felt in Russia, but has caused repercussions around the world. And China is in a particularly delicate position given its close ties with Russia. So joining me for the discussion today is Ben Kostrzewa, a sanctions and trade specialist from Hogan Lovells. Ben has years of experience working in the US government and also in private practice. And I think he's a perfect person to talk to us today about this topic. I will start by asking Ben several questions that will take about 30 minutes. And then I will open up the floor for questions. Now, I would also like to remind the audience that throughout this talk, please feel free to submit your questions in the Q&A box. And at the same time, I want to remind you that the Chatham House rules apply. So if any media friends want to quote Ben on any of the comments he made during the talk, please contact him individually and to get his clearance and permission. Now, let's all welcome Ben. Hello, Ben, how are you doing today?
I'm great. How are you? Greetings from Washington, D.C.
Wow. So I understand that you are usually based in Hong Kong, but you also travel quite a bit, right?
Under normal times, I travel a lot. Of course, with COVID, I've traveled less, but I moved from Hong Kong from Washington, where I've spent a lot of time here, and I used to work in the U.S. government at the Office of U.S. Trade Representative, and I've always focused on U.S. China relations and international trade law. And so usually I get to talk about U.S. China relations, but of course these days Russia is on the top of everyone's mind, and it really does affect U.S. China relations and U.S. China sanctions and export controls policy and how Chinese companies need to face the world.
Right. Now, let's start by, let me start by asking you a very big question. I mean, a very broad question. Give a kind of like an overview of like the scope of the sanctions that have been applied on Russia, and so we get the big picture of what's going on so far.
Of course, yeah, and that could take a very long time to talk in depth, and so I'll try to give an overview quickly, and then we can go into more detail as need be. Because I'm a U.S. China trade specialist, I was amazed over the last 3 or 4 years under the Trump administration and the Biden administration at the speed in which the United States has put export controls and sanctions, and we'll talk about those separately a bit, on China. But as much as the speed over the last 3 years have affected U.S. China relations, the speed in which sanctions and export controls have put on Russia in the last 3 weeks has been incredible. And so it has really been an incredible response on the US, the UK, Europe through the EU, Australia, and then other countries like Singapore and Japan to sanction Russia in some meaningful ways. And those are very broad. And so the most important thing is all of the SDN designations, the specially designated nationals. And so that's the same sanction that was put on Carrie Lam a few years ago, where she's not allowed to interact with the U.S. financial system, which is pervades the international system. There are also so many restrictions on Russian banks. Some of them have been added as SDNs. Others, like Sberbank, which is the biggest bank in Russia, has not been added as an SDN, but has been prohibited from adding correspondent accounts, from doing USD transactions. Then, of course, there's also the Russian central bank, where we've seen, half of Russia's foreign currency reserves frozen, the freezing of airspace for Russian companies, the withdrawal of U.S. companies from Russia, the ban on the import of liquid natural gas and coal to the U.S. and the U.K., and restrictions on European Union, new investments from the U.S. and other countries on the Russian energy sector, import bans in the United States on Russian goods like seafood, alcohol, diamonds, an export ban from the United States on luxury goods to Russia, other restrictions on debt and equity to certain companies in Russia that have expanded the sanctions that already existed after the Russian invasion of Crimea. Then there are secondary sanctions, which we can talk about in more detail, because I think that's really important for Chinese companies. And then separately, export controls, which controls the export of United States goods to Russia. And then other things like a possible expulsion of Russia from the WTO, the revocation of permanent normal trade relations with the United States and other countries, and G20. So this is a broad and international sanctions response against Russia. We've seen as a result of that there's been a lot of economic repercussions in Russia immediately. And it really affects companies around the world that have any interaction with them. It doesn't change all things. I want to make that clear. Like, Russia is not the same right now under U.S. law. And because I'm an American lawyer, I'm going to focus more on the U.S., but we can talk a little bit about UK, EU, and other jurisdictions. Russia is not the same as Iran or Cuba or North Korea or Syria, where there are comprehensive sanctions that basically end all transactions with Russia from the United States. But there are a lot of restrictions. So there are ways in which Chinese companies can still trade with Russia. There are ways in which the United States can still trade with Russia. But these sanctions are very, very significant and have really changed the landscape with Russia, and as a result of that, changed their economy.
Right. I mean, some people say this is not sanction. It's like almost like an embargo, and in some sense. And in addition to those sanctions imposed by governments, we also see companies are imposing their own sanctions by walking away from the Russian market. And so based on your years' experience as a trade and sanctions specialist, what do you see is like particularly unusual, that it's kind of unprecedented, you've never seen before in your prior practice?
I mean, I think that the speed is incredible. We really have seen, I think everyone has been surprised by the speed in which the international response, the United States sanctions response is significant, but maybe expected. But that the EU has come along with these sanctions, that Switzerland, which maintained neutrality during World War II, has also put in sanctions against Russia, that Germany has, in spite of its reliance on Russian energy products, has really come about on that. So I would say what stands out is some of the energy restrictions. I think the SWIFT restrictions were a little bit surprising, and I think the seizure of Russian foreign currency reserves of $300-some billion was surprising as well. And that has really changed the economic system, and it certainly makes all of these more real. Those are surprising, as well as the wide SDN, specially designated nationals, means that you really can't interact with the international financial institution in any meaningful way, and put secondary sanctions on the people who are added to that. And that makes it very difficult for anyone all over the world to interact with anybody on this SDN list.
Right. I mean, you mentioned that a lot of surprising sanctions that we haven't seen before, but are these surprising sanctions, are they more of symbolic, or do they really have real teeth here? You mentioned SWIFT. There's a lot of discussion about, cutting Russia off SWIFT lately. Some people describe it as kind of like the nuclear financial weapon. But there's also people who say, look, SWIFT is just a messaging system, and it's not really have real impact on Russia's, financial, reserve. So in any way, I mean, the bank, they can still communicate by other means. So can you tell us, like, what do you think about among these surprising sanctions, which are more symbolic and which have real teeth here?
Yeah, I think we're still figuring that out. Like, I was reading that the ruble went from 120, 160 rubles to the dollar, and now it's back closer to 80 or 90. And so right now, it's a very volatile situation. And so I think we're going to find out over the coming weeks what has teeth and what doesn't. And, sanctions are a slow response to a kinetic war. The war that's happening in Ukraine it's very fast. And for those suffering, throughout Ukraine, these sanctions probably don't matter a lot. And so we will find out how much pressure they put on the Russian government to change behavior. And sanctions are designed to change behavior at a national security level, but no matter what, they're not going to happen as fast as a war happens. Right. And that's important for all of us to recognize. Even if they happen, they take time to put that pressure. And withdrawal of Western companies from Russia, Russia really being isolated from the economic system matters, but will it change behavior from Russia? We don't know right now. I'd like to think that it'll end a war faster as a result of them, but we've also seen sanctions in place for many, many years that have done nothing but, hurt the common people and not help end the national security interests of the United States or other countries. I think that the SWIFT restrictions have gotten a lot of press and were seen as not possible up until the invasion. And then when the invasion happened, the EU realized that this was necessary. I think the SDN restrictions, which in some ways are much more comprehensive than the SWIFT, which are, as you said, is a communication through the international financial system and is only on a number, I think 8 Russian banks, and has some exceptions to it where like energy transactions are still allowed, matters a little bit less, even though it's getting a little bit more press. And so those are less so. On the other hand, the seizure of hundreds of billions of dollars, I think, has a real effect. And so right now, we don't know which ones will really change behavior, but we know that Western companies realize that even if they're not directly affected by the sanctions, they are going to have trouble moving money in and out of Russia. They know that there's political pressure to be removed, and all of that puts more pressure to hopefully end this war faster than otherwise. Right.
So it seems very complicated. Only time can tell which one have real teeth.
I wish I had a good answer otherwise, but I'm sitting here talking about the rules and the law, but of course we're 5 weeks into a real conflict, and we don't know what will happen next.
Right. Now, let's get to the point about secondary sanctions, which you already alluded to, and that have been mentioned a lot in the press, because it appears there is a general impression among the Chinese that, as long as, the U.S. hasn't opposed secondary sanctions, it seems the Chinese companies are doing just fine so far, because it's mostly applying primary sanctions. And from what I'm reading, my limited understanding of the sanction law and the distinction between primary sanction and secondary sanction are extremely complicated. So I would like you, first of all, if you can give us kind of a 101 of how do we distinguish these two types of sanctions? If you can give us some examples to illustrate that. I mean, back in 2018, Chinese companies Huawei and ZTE were also subject to sanctions. Like, for instance, are these primary sanctions or secondary sanctions? Yeah, I mean, that would be very helpful before we move on to later discussions.
Sure. So I think this will be my short lecture, and hopefully I don't put everyone to sleep, even though it's morning in Hong Kong and evening here. But so we need to talk about primary sanctions, secondary sanctions, and export controls, because each of those are a different bucket. So primary sanctions apply when there is some sort of nexus with the United States or with the UK or EU. So we'll put those jurisdictions aside for a section. And so that's either a US person, a US dollar denominated transaction, or in some cases, a US good. And so me as a US person has far more restrictions on conducting a transaction with a specially designated national. So whether that's Vladimir Putin, Carrie Lam, the banks that have been designated in SDN, either persons or entities, I can't conduct virtually any transaction with them without permission from the US government. You need a US nexus for primary sanctions. Secondary sanctions are more limited, but that has a qualifier. That means either material support for these SDNs or other designations on other restricted parties, or significant transaction. And so what does material support or significant transaction mean? Those are discretionary terms that the US government uses, and there's a 7-factor test for what a significant transaction is. There's a variety of cases for what material support means, but they have a lot of discretion. Like they've used it in the Iran situation for oil shipments from Iran and facilitating oil to there. But there's a lot of discretion for how the United States government, through the Office of Foreign Asset Control and the Department of Treasury, OFAC, how they'll apply this. And because there's a lot of concern that Chinese companies may avoid the sanctions on Russia, secondary sanctions should be a very big concern for Chinese companies. And that means that it's one thing if you're a Chinese company in northern China and you have regularly worked with across the Russian border, you have a factory, you're bringing in material goods, nobody's an SDN, you're probably not that worried about US sanctions. On the other hand, if there are a number of other concerns, if you're conducting significant transactions with SDNs, you could very well find yourself designated yourself. And so for those that followed the Hong Kong Autonomy Act in 2019 and 2020, you know about these secondary sanctions. You know that there could be these repercussions, even if you're not touching the US financial system or the international financial institution. So that's primary and secondary sanctions. Then Huawei and ZTE, those are export controls. And so that's different and more limited than primary or secondary sanctions. That has to do with the export of goods. So rather than a financial transaction, rather than me sending you money or us, doing a loan deal or all the other things, this is really about me exporting a US good to Huawei. And so for Huawei in particular, worrying about semiconductors, worrying about high technology. And so Huawei has a lot of limitations on US export controls to Huawei, but as a US person, as myself, I can conduct a financial transaction with Huawei. They're not an SDN. They're not subject to the financial restrictions. So when you think of primary and secondary sanctions, you think of restrictions on either money or persons. And when you think of export controls like Huawei, you think of transactions of goods. And frankly, the export controls are far more complicated. And now Russia has a number of export controls. So if you are a company in China who incorporates, say, microchips from the United States and then exports them to Russia, you need to worry about the new export control rules. But if you're only conducting financial transactions with Russian companies, you should really be thinking about them in terms of, are they SDNs? Are they restricted parties? Are they subject to the myriad other restrictions on Russian companies? So hopefully I haven't seen the attendee list go down dramatically in my lecture, so hopefully I didn't bore anyone too much. But that's the general buckets of primary sanctions, secondary sanctions, and export.
Let me follow up on the Huawei case. I recall that the arrest of the Meng Wanzhou and also the subsequent punishment on Huawei has something relating to the sanction against Iran, because Huawei was suspected to have some dealings with Iranian companies in violation of the U.S. sanction against Iran. And the transaction definitely occurred outside of U.S. territory, although they probably used HSBC's financial network. So would that be sufficient to constitute as a U.S. nexus, and that will be a violation of the primary sanctions?
So what I think what happened with Huawei is they took U.S. goods, incorporated them into Huawei technology, and then exported those goods to Iran. And so they violated export controls. They may have also violated OFAC sanctions, where they conducted transactions with Iran, and those could have been secondary sanctions, assuming they were conducted in renminbi or another non-US dollar denominated transaction. But as I recall, they were really in violation of export control rules, where because I'm going to go more into the weeds and I'm going to watch the attendees fall asleep. But U.S. export control laws and these sanctions, they're applied extraterritorially. That's why if you're a factory in Nanjing or wherever else, you have to worry about U.S. laws. And of course, this frustrates China to no end in other countries, that you have to worry about U.S. laws even though you're anywhere in the world. But U.S. technology could be something that is produced in the United States, or it could be something where you've incorporated enough U.S. technology into your product, and then that becomes also subject to U.S. law. And there's a few other ways in which it can be as well. There's this foreign direct product rule that's more complicated than it's worth talking about now. But what Huawei did was they took technology, took products from the United States, put it into their products, and then shipped it to Iran. And they also, they weren't honest about it. They didn't try to get a license from the United States, which is possible. And so that's really where Huawei ran into trouble, and that's why they're on the entity list, which means that any U.S. company that wants to do business with Huawei needs permission from the U.S. government beforehand. And companies I think there's something like half the companies that apply for a license to do business with Huawei still get it. So it's not as though it's a complete restriction on Huawei to be on this entity list, but it makes it's a much bigger headache.
Right. So far, has U.S. imposed any secondary sanctions on Russia? And what about this, export ban of technology to Russia? Then that doesn't count as sanctions. It's more like an export control type of thing.
So secondary sanctions apply. The executive orders that apply to Russia have the secondary sanctions incorporated into it. It's too early where there are any cases. There has been a recent enforcement case that predates the Ukrainian crisis, where somebody was found to violate U.S. sanctions because there was a U.S. person working for a Russian oligarch. So they exist now. Right now, if you're a Chinese company, you need to worry about secondary sanctions. And given, sitting in Washington, talking to Washington policymakers, Russia is the crisis of the day, but the U.S. China tensions that have pervaded relations for the last few years have not gone away. And there's added concern given the communique between Russia and China during, in early February during the Olympics, where there's a lot of concern that Chinese companies will support Russia in violation of U.S. sanctions. And so there's going to be a lot of enforcement actions in China on both the primary sanctions and the secondary sanctions and export control rules, because we don't know right now. And in my experience, Chinese companies have taken U.S. law very seriously, and they have worked hard to comply with it. But right now, they think that if some companies support Russia, in violation of these rules, you're going to have violations. And so there's a lot of expectation that there's going to be investigations and enforcement actions against Chinese companies.
This is a very important point here. So I would like to pause here and then ask you to clarify the secondary sanctions, because the impression that we got from the press, being a non-specialist, is that there so far hasn't been secondary sanctions. But what you are telling me now is very different, is that the secondary sanctions have already been attached to all these sanctions, or maybe some part of the sanctions. Could you clarify a bit about the scope of the secondary sanctions that have been imposed?
Sure. So the main executive order that has created a lot of the SDNs against Russia has a material support clause, and if you have material support of an SDN, you can be found to be in violation. And to be clear, the penalty for violating secondary sanctions is very different from primary sanctions. For primary sanctions, if you found to be in violation of them, you might be subject to fines. You might be, in very extreme cases, you be subject to criminal penalties, export bans, and other things. But companies, whether intentionally or unintentionally, violate primary sanctions all the time. For secondary sanctions, the penalty usually is to become an SDN yourself. And so it's an less likely enforcement because you have a materiality clause or a significant transaction in some other situations. But the penalty is pretty severe, where if you become an SDN yourself, you're also cut off from the international financial system.
Right.
So there are secondary sanctions in place right now that Chinese companies and others need to be concerned about.
Right. And could you also comment on the technology ban on Russia?
Yeah. So there's also a export control restrictions on Russia that looks a lot like Huawei. And so if you are a U.S. company who exports technology, and particularly technology that is subject to the EAR, so U.S. items, and it has an ECCN, so is classified under that, you need to be very cautious. Or if you're a Chinese company importing US components and then exporting them to Russia, you need to also be very cautious. If you're a Chinese company, everything is manufactured in China. You have no nexus with the United States. You aren't working with SDNs in Russia. You just have a factory there and you're building, you're probably okay. As a lawyer, I would never say you're 100% okay. Don't take this advice. Give me a call. But there are ways that Chinese companies can continue to trade with China. I don't want to give the impression that this is a blanket ban. But for export controls that affect the United States, also the EU and the UK, you need to be much more cautious than you needed to be 3 months ago.
So let's talk about the big question about what is the US person, because that seems to be a basis for finding primary sanctions. And then from what I've read in the literature, is to find a US nexus is quite, quite broad. So now let's imagine that I'm a Chinese company that is listed in the United States, right? I mean, I'm a Chinese tech company listed in the United States, and just have a tiny subsidiary office there, or maybe I have no office there. I'm listed in the US. Will I be regarded as a US person?
No. If you are a Chinese company and your only nexus with the United States is being listed on the New York Stock Exchange or NASDAQ, that is not sufficient to be a US person. That nexus doesn't matter. It's a US person, and so whatever that means, whether that's a US citizen or a green card holder, if you're a US person. If you're in the United States, if you're a company in the United States, whether or not how you're owned, that's a US nexus. If you are 50% or more owned by a US company, wherever you are in the world, you're a US company. And then this is where it gets a little complicated. For some sanctions laws, subsidiaries abroad may count. But if you're a Chinese company that is owned by Chinese persons or by non-US persons, you are not a US person. And it's pretty well defined in US law for what a US person is. This is a question that I've spent the last 2 weeks talking about a lot. And then there's other complications. If you're a US person working for a Chinese company, how can you interact with sanctioned persons? But for Chinese companies that are worried about this, you can usually get a pretty definitive answer for whether or not you should be considered a US person, either under sanctions rules or export control rules.
But the reason I asked this is because recently there is a case where there's a Korean company actually has very little nexus with the United States, and they are listed in the US and they have a tiny subsidiary in the United States, and they were prohibited from selling assets to a Chinese company under FIRMA, the U.S. National Security Review Commission. So the interpretation of a U.S. person, at least under FIRMA, is very broad. That the fact that you are listed in the U.S. and has a tiny subsidiary there is sufficient to find you a U.S. person. So, but based on what you see, told us that it seems like, at least under Sanctions Law, there's more restraints to identify a U.S. person.
Right. This is why I'm very busy, is these laws are complicated. FIRMA has to do with CFIUS, which is the Committee on Foreign Investment in the United States, and that is inbound investment in the United States. So that's a different legal regime than the sanctions rules and has different laws applying to it. And so if you are a Chinese company looking to buy a company in the United States or looking to buy technology, those rules are very broad, but very different from what we're talking about now. I'm not familiar enough with the Korean situation, so I can't speak to that. But but that is a different law than what we're talking about now. U.S. persons, there is a fairly definitive rule in the OFAC regulations as well as case law to make a determination on whether or not you're considered a U.S. person. And it's a pretty bright line rule. So the U.S. uses a 50% or more ownership test and doesn't have a control test. It doesn't look at board of directors and everything else. Whereas the UK and EU rules looks at a control test. So you can't just look at stocks, or at ownership. So there are a few different ways to do it, but you can come up with a determination if you look at the rules.
Right. I mean, so let's assume that this Chinese company had absolutely no nexus with the United States and will have no chance of being identified as a U.S. person. Now, if they continue to trade with Russia, but even avoiding all this potential problem, like using no U.S. financial network, I just trade with Russia in yuan. Based on what you have told me, they could still be found in violation of secondary sanctions, right? I mean, is that true? Or is there a way they can get around the secondary sanctions if they use no US, they don't use Android operating system, no Gmail, no Swift?
So I just advised a company on an issue like this, where they had a factory in Russia and they were importing goods from the EU. Those goods are starting to run out because they can't import those goods from the EU for a variety of reasons, mostly having to do with the restrictions on banks. So they're moving their factory from Russia to China, and they're going to make what they make. We'll call it this. This is lip balm, right? Like not a high technology, doesn't really matter. And they are taking lip balm, and they were going to make it in Russia, and now they're making it in China, and they're going to manufacture that lip balm in China, and then they want to export it to Russia. And they're checking to make sure none of their customers are SDNs or other restricted parties. All of their transactions are renminbi. There is no US persons involved. There's no US technology in the lip balm. That transaction's okay. There is no US nexus. There's no SDN. It's not a material support of an SDN. There's no significant transaction. So they're not violating either the primary sanctions, the secondary sanctions, or export control rules. So there are a lot of ways in which trade can continue for Chinese companies around and other companies with Russia, as opposed to North Korea, where there are really blanket restrictions. Now, on the other hand, if they were using US dollars, or if maybe one of their customers was one of the Russian oligarchs, and they were trading hundreds of millions of dollars with a Russian oligarch that's on the SDN list, then they need to be worried about the secondary sanctions, even if it's all in renminbi, even if there's no US persons involved, then they need to be worried about significant transactions with an SDN. And that's where, so what I advise on is compliance rules. And the number one compliance rule is screen your customers. Know who you're working with, both in terms of your customers, business partners, and if none of them pop up, you can screen fairly easily. There's commercial ways to do it. There's private ways to do it. There's lots of ways. But if you know who your customers are, and none of them show up on these lists in the United States or the EU or the UK, then you can probably continue your business. You just need to add a little bit of focus on making sure you're not working with all these people being added to these lists.
So just avoid these people. That will be a simple and safe rule.
The simple and safe rule is to avoid them completely. There are also ways in which you can conduct transactions with them where it's okay, and especially if you're avoiding a US nexus. But the fastest way to avoid it is to just not do business with sanctioned parties.
All right, let's talk about the anti-sanction laws that China adopted last year. That also caused a lot of concern among multinational business companies, right? I mean, and given the fact that maybe at some point, a Chinese company might be found in violation of some sort of US sanction, whether primary or secondary sanctions, then we need to be concerned about anti-sanction rules, right? I mean, given the fact that these companies might be found on the SDN list, the Chinese company now be on SDN list, like, what kind of challenge would it pose to foreign companies, like, operating in China? I mean, what kind of challenge they have, in dealing with this kind of Chinese firms?
Yeah, the Antiforeign Sanctions Law came out and concerned a lot of companies, and it remains a significant concern. And I advise companies all the time on how to draft their rules with contracts with their Chinese counterparts, even their Chinese subsidiaries. And the Anti-Foreign Sanctions Law is written very broadly, where it appears as though China could either, through the Chinese government, impose rules against foreign companies for complying with foreign sanctions, or permit Chinese companies to pursue litigation against foreign companies if there's harm against them for sanctions. Now, on the other hand, we're now 8-9 months since the law has been passed, and there has been no enforcement or cases by the Chinese government for sanctions compliance within China. And so the greatest fear hasn't happened yet. That doesn't mean it won't happen. China could take action under the Anti-Foreign Sanctions Law against companies complying with US or UK or EU sanctions, and we could be in that situation. But so far, all the enforcement actions under the Anti-Foreign Sanctions Law has been against politicians who have imposed rules against China. Wilbur Ross, Donald Trump's Secretary of Commerce, is under that rule. Senator Rubio, I believe, is under that rule. They impose sanctions on Raytheon and Lockheed Martin for arms sales to Taiwan. And all that can matter some, but I don't think Marco Rubio is planning a trip to China anytime soon. Raytheon and Lockheed Martin don't have much business there. And because the United States imposes a lot of influence because they have so much effect on the international financial system, where there are a lot fewer transactions with renminbi. And so the Chinese sanctions are not as extraterritorial. And informally, what I've heard is that Chinese companies are taking these sanctions on Russian companies seriously. There's the rhetoric at the political level, but then big Chinese banks, they don't want to be cut off from the international financial system. Companies that do business don't want to, be cut off from U.S. goods. And so there are a lot of different ways in which Chinese companies are complying with these rules in spite of the Anti-Foreign Sanctions Law.
Well, excellent. Let me ask you one last question before I open up the floor for Q&As. And I would like to encourage the audience to put in your questions right now. Now, let's talk about the end game here. There's been some talks of potential ceasefire soon. And in exchange, the West might be rolling back some of the sanctions, which is good for Russia and potentially good for China as well. So could you comment on, are there, from a lawyer's perspective, right? I mean, do you see any legal challenges of lifting up some of the sanctions that have already been imposed?
So the way these are imposed are through executive order, so through the Office of the Presidency. And so they can be imposed very quickly and they can be lifted very quickly. And currently there's no U.S. congressional legislation that would prevent the president from lifting those. That's in comparison to Cuba, where, for those that follow this closely, President Obama wanted to lift a lot of the restrictions on Cuba, but there was actual legislation from U.S. Congress that prevented him from doing that. And so that created a legal conflicts within the U.S. system that made it harder to do that. And so I have no idea what will happen in Russia. I think these sanctions will be in place for a long time. On the other hand, there's a lot of pressure. I mean, Russia supplies a lot of energy. Russia and Ukraine supply a lot of wheat and corn. And of course, we're dealing with a time of high inflation in energy and food prices. And so if there was a ceasefire, if we found a meaningful resolution to the conflict, or if there was a change, you could see these sanctions being lifted very quickly. There's not a legal restriction for these to be lifted. If Congress does get involved, if they do actually manage to pass a law, and no one would bet on the U.S. Congress to do anything quickly these days, but if that were to happen, if they were to say, no, you're not going to lift restrictions on Russia unless X, Y, and Z happens, then that could change. But right now, if tomorrow there was a meaningful end to this war and there was, you could see these rules changing very quickly. But by and large, it's just in terms of politics, not in terms of law, it is easy to put people on the SDN list. It's easy to restrict them. It's harder to lift them, right? Nobody wants to be seen as soft on Russia, soft on China, soft on the terrorists that are on the list. So it is, as a matter of policy, it's harder to remove. In Washington, everything comes down to policy, politics, people, and process. And all of those often militate towards slowing down how removing the restrictions on sanctions.
That's an excellent summary of the U.S. process. Thanks, Ben. So let me open up the floor for Q&A. And we have a lot of interest in your talk, Ben. So we have over 340 registrants for today's talk. And first question, I'm interested in hearing your opinions on how effective the sanctions on Russia oligarchs would be at this time, and how important are these sanctions in in overall picture of sanctions. I remember reading a newspaper very recently saying that those sanctions are didn't seem to reach the companies that are owned by these oligarchs. So it seems to have quite limited impact, although they free some of their assets. So if you may comment on that.
Sure. I think it's too early to tell. I see in the question that you're right. The annexation of Crimea, the sanctions that were imposed were very limited. And so the sanctions on Russian oligarchs, I think, are immediately biting and changing. I was just in London for a few weeks where, Londongrad and the money that has come into London from Russia has had a big effect. And I think oligarchs are very nervous. On the other hand, I just saw that, Russian-owned steel was still Russian oligarch-owned steel company was still being imported into the United States. And they have they have a lot of different interests around the world, and there is limited amounts of enforcement. Of course, we've talked mostly about the law in its theory, but in practice, you need people to enforce. You need a shipment to be inspected and for the ownership structure to be inspected in order to actually stop a lot of these. And so I think it has a real effect on these oligarchs around the world. Minimally, they're moving their yachts around to hide them from these sanctions. But money puts a lot of pressure on systems, and it'll be harder to enforce these rules than it is to impose them. So I think we'll know in another 6 months how limited these people who are fabulously wealthy and have a lot of power and influence around the world, how much their behavior, their money is actually changed.
Right. The second question, I guess, is from a law firm. Now, imagine I am a Chinese law firm, and if I provide legal advice to a Russian company, let's assume this is an SDN company, and in China, would I be potentially in violation of a secondary sanction? I mean, I guess from what you're saying, you need material support for SDN, significant transactions, or giving legal advice, would it count as secondary sanctions?
You're probably safe. The rules are written by lawyers, which always helps lawyers. And one of the exceptions is, so like me, I'm a sanctions lawyer, and I don't work with sanctioned parties, but sanctioned parties can receive advice about being sanctioned. And so probably if you're a Chinese company working with a sanctioned party and you're providing advice, that's probably not material. It's probably not a significant transaction. I can tell you that most law firms, including my own, don't do that for fear of either the sanctions or the political repercussions of doing that. But this is all case by case and very fact specific analysis. So it's hard to say in theory, but in general, a sanctioned party can get advice for how to comply with sanctions. If they get advice for how to buy a company, that could then depend on if there's a U.S. nexus and then how big the transaction is.
Well, in your case, it's a bit different, right? I mean, because you are a U.S. citizen and working for a U.S. law firm. I mean, so I assume for these Russian oligarchs, can they still get advice from U.S. law firms at the moment? I mean, assuming, the law firms still want to continue working with them, but would the U.S. law firm be violation of some sort of primary sanctions because the U.S. person?
Can, yes. If it is outside the realm of providing advice related to the sanctions, it is probably a violation of sanctions law. If it is unrelated to compliance. So and I have turned down clients. If you're a Russian SDN and you want to buy a company unrelated to the sanctions, and you call a law firm and a U.S. law firm, and they provide that advice, and it's unrelated to any sort of sanctions compliance, that firm is running a great risk of being found in violation of those sanctions.
Right. Okay, the third question that we have here, screening counterparties on the SDN list may not detect which one is 50% owned entities or entities becoming SDN subsequent to signing the contract. I mean, this is coming from a very experienced lawyer, probably.
So this person wins a gold star for identifying what's even another depth, which is shadow SDNs. And so there's the SDNs that are listed, which you can search on the US website. But then any company that has owned 50% or more by an SDN, whether by one or two different SDNs combined, is also considered an SDN, and we call those shadow SDNs. So if Russian oligarch A owns 30% of a company, Russian oligarch B owns 30% of the company, and both of those are SDNs, that combines to be 60%, and then that company that they own is also an SDN, even though that's much more difficult to figure out based on a simple search. And that is what creates a lot of uncertainty in the system. some commercial searches are able to identify some of those shadow SDNs. Doing careful research on who owns a company, if you're doing know your customer, KYC diligence or anything else, but that creates a lot of uncertainty. So they are absolutely right that you need to be very, very cautious if you think that if this is within the purview of any SDNs, you need to do your diligence.
Right, I mean, that's excellent advice. There is a question about whether U.S. can afford a secondary sanctions against China. I guess that's probably, I don't know whether you feel comfortable commenting on this question, because it seems like to be beyond the realm of the sanctions law. I mean, it more goes towards, financial interdependence between U.S. and China and geopolitics. Or if you want to say anything in regards to that.
Whether they can afford it, of course, there's all sorts of questions there. I think that the direction in Washington is to continue decoupling, and there is a lot of emphasis on sanctions and export controls enforcement in China, and so I wouldn't rely on inability to enforce these rules or lack of inclination to if you're a Chinese company. Of course, enforcement is limited. There's only so many people out there policing these, but I don't think there's a lack of desire to ensure that Chinese companies are following these rules.
Right. I mean, given the bipartisan support of a very tough rule against China these days in Washington, D.C. Now, there's a question about, what would be the penalty if a company is found to be in violation of secondary sanctions. I recall you mentioned that the potential penalty will be the company will be put on the SDN list. But what about, is there any repercussions on its top executives, like, and its shareholders?
Yeah, complicated question. There's a lot of different permutations to that. Depends on the knowledge of the executive officers for whether or not whether or not they know about this. Secondary sanctions, though, the main penalty is they also become a sanctioned party. That is how these rules generally work, as opposed to paying a fine. Whether or not top officers or shareholders, usually not, I would say, but certainly individuals can have personal liability under U.S. sanctions law, and there are criminal penalties, there are civil penalties, and that happens with some frequency. So it is part of the reason why you need to be very, very cautious, is because they will hold individuals accountable.
Right, but if they hold them accountable, it will be explicitly, stated, right? in the penalty, right?
Oh, you'll be named in an indictment by the U.S. government. You will be very aware if the U.S. government comes after you, or if you're named as a sanctioned person.
Right. Look, because that reminds me of China's anti-sanction law, because I vaguely remember there's some sort of liabilities for the executives in supporting anti-sanctions, in supporting sanctions against China. So now, how do you comment on some international sports organizations' sanctions on the Russian athletes? I don't know whether that's beyond sanction law. If you want to say something about it, Ben.
It's beyond my legal abilities. Of course, I love sports. And it makes me sad when sports it is unable to be a bridge across cultures. But given the deep involvement of the Russian government in sports, it's not all that surprising that'll happen. So I would, of course, prefer the purism that is sports around the world, but it's not surprising that they've chosen to also penalize individual athletes and teams.
Right, it's not just sports, right? Almost all the Western companies have cut ties with Russia, and even Chinese companies like Didi want to leave the Chinese market, but then face controversy in China for walking away from Russia. So all companies now, for those that have any ties with Russia will need to think about, ethically, morally, do I still want to continue operating in Russia, trade with Russia at the moment?
And logistically, like, the Bolshoi Ballet is unable to travel, and there's bans on Russian flights, and then all the restrictions on transactions. So most companies have left Russia, and whether that's an ethical or moral change, or just we don't know how to do business, we don't know how to ship goods in and out of Russia while still in compliance with these sanctions. We don't know how to pay people because maybe they were using a bank that's now an SDN. And so it puts incredible pressure in a variety of ways because of the financial system. And so even like sports or ballet or these other, seemingly unrelated areas are still very much affected by these pretty broad sanctions.
I guess to some extent that also opened up the market for Chinese companies, right? I mean, given these Russian businesses or these Russian needs are not put on the SDN, so Chinese companies can legitimately operate and cater to that demand in Russia, right? Without violating Sanctions Law, I guess, right?
Yeah, I think that it was probably part of that communique that came out, and the alliance that has grown between Russia and China, an uneasy alliance, but certainly one where there's hope that Chinese companies can fill that void. And there are ways in which they can do it and comply with these international sanctions rules.
Right. I mean, we have about 3 minutes left, Ben, and still a lot of questions. We try to get to as many as we can.
I can stay as long as you want.
No, it's very late for you in DC, so we'll let you go at 10:30. So appreciate your thoughts on the justification of lifting the battlefield to the next level, like restricting people's freedom of basic rights. I think that went beyond the sanction topic that we are talking about. Is it? Or the sanctions like restrict people's freedom or basic rights? I mean, indirectly, maybe, right? I mean, because
I think that's a philosophical decision. The United States, of course, would disagree. They're saying that they are applying rules based on the United States interests, and that it is not violation of human rights to use the international financial system to do business. That is not recognized in the UNHCR. So I would say that's an overstatement to say it's a violation of human rights that there are sanctions, but I also appreciate that there's a lot of frustration, particularly in China, of these rules as being extraterritorial. But I think that's a little beyond what I could possibly answer in a few minutes.
This question is more relevant to Sanctions Law, Ben. So what would you predict is the future of the Sanctions Law? I mean, I guess you will be the perfect perfect person to answer this question, because you observe the changes of your practice over the years. And from my interaction with you, you got busier and busier every day in the last few years, starting with the U.S. trade war, and now the Hong Kong situation, and now the Russian Ukraine war. It seems like this tension seems to be escalating, and there's a greater demand for Sanctions Law, right? I mean, so what is it going to affect us eventually?
I think I don't take any solace in this. I believe in integration in terms of globalization. I think U.S. China integration has been overall positive in general, but the direction of the world right now is to emphasize less integration in the world, whether that's through sanctions and export controls, other limitations on investment, focus on domestic consumption and industries, both in China and the United States. I think there will continue to be slow growth of sanctions and export control rules on China, barring a crisis. We'll continue to see restrictions like on Huawei and SDN listings of officials or others. I don't think it'll explode. I think that we will still sit in this space where it just gets a little harder for that integration that we used to kind of take for granted between the US and China. Whereas now companies are going to really need to think about their supply chains in a meaningful way and whether or not they comply with U.S. law, Chinese law, EU law, etc.
Great, thank you, Ben. That was a terrific session, and we're trying to get to as many questions as possible, but there's still a couple of questions that we haven't been able to answer. But I really appreciate that you stayed up so late and come and join us for such a terrific session. I personally learned a great deal. I think you're a wonderful teacher, Ben. I found your example.
So two things. First, I have a very easy last name. Feel free to friend me on LinkedIn or anything else, and we can continue that conversation there. Two, nobody knows this, but Angela and I are old friends. We took the LSAT together way back when, and Angela smoked me in the LSAT in her second language, and she went off to great things in law, and I'm so grateful to be her friend now and to join you in this session.
No, I'm really, really pleased and honored to have you here. And I think our students and our community benefit a great deal from this talk. And thank you very much, Ben. And have a nice evening. Thank you.
Thank you. And I look forward to seeing everyone in Hong Kong in a few weeks. I look forward to being back on the streets of Hong Kong in just a couple of weeks.
And thank all the audience for joining us. We'll have more talks in the coming weeks on the law and geopolitics. So stay tuned. Bye-bye.